get into the topic here. By way of introduction, over the past century plus, the U.S. federal courts have crafted rules and tests concerning when contractors are entitled to time extensions and when they're entitled to both delay and or impact damages. Contractors, owners, construction managers are frequently involved in time extension issues. Contractors, obviously, if you're a contractor, you're the one that has to submit the time extension request to the owner, and you have to deal with requests you receive yourself from subs, suppliers, or vendors and determine whether or not it should be passed to the owner if the owner is actually responsible for the alleged delay. And in that process, contractors, you may be required to certify the validity of the subcontractor's delay request, which has certain legal ramifications that go beyond the context of this webinar, but know well that it is a serious issue for you to contractor to determine that I'm going to sponsor this claim to the owner because obviously the owner is responsible. That has legal ramifications you need to explore. Construction managers at risk. Obviously, if you're the CM at risk, you have the direct construction contract with the owner, and so you may be required to file time extension requests from the owner. And again, you have to deal with the requests you have from all of your contractors, subcontractors, whatever. And likewise, as mentioned earlier, you may be required to certify the validity of those requests. Now, when I say certify, many of the statutes, both federal and state, and many contracts require you to certify such things under penalty of perjury, which obviously is an issue you should talk about with your own legal counsel before you do it. Agency construction managers. An agency construction manager is somebody who signs on to act as the owner's representative for the duration of the project. Typically, agency construction managers have no authority to make final decisions on time extension requests, although every time I've ever worked on a team that was in an agency construction management relationship with the owner, one of our duties under the contract was to receive all claims submitted by contractors, all time extension requests, all change order requests, analyze them and make a recommendation to the owner of what they should do with this thing. Accept it, negotiate it, fight it, whatever. And then finally, owners. You're listed here at the bottom of the chart, but the bottom of the slide. But what it really is you're the folks who receive all this stuff either directly or via an agency CM, but you're charged under the contract with making the final decision on all time extension requests. So the point we're making here is contractors, owners, construction managers have to know the rules regarding time extensions requests, what needs to be shown, when is a contractor entitled to one, when they're not entitled to one, so on and so forth. If you don't know the rules, you are more likely to end up in arbitration or litigation because you will not have operated appropriately under your contract. Now, most contracts have three types of delays specifically discussed in the contract. However, there is a fourth type of delay, and so let's take a look at these, and I'll explain in a minute why. Well, I'll explain now why we're doing it. Each one of these four types of delays, once you drill down to the bottom line of the responsibility or what's called entitlement under the contract, once you drill down to the bottom line, each one of these types of delay renders an entirely different decision on who gets the time and or who gets the money related to that time. And that's why we want to cover these things at a high level to kind of set the stage for you. Now, the first type of delay is what most contracts refer to as inexcusable delay. And this is delay that typically is delay caused by the contractor or one of their sub-suppliers or vendors at any tier, and the end date of the project schedule is impacted. That is, as of this date, we're supposed to finish on August 15, 2019, but because of this event, the contractor is saying we're now going to finish on December 1st of 2019. Those impact the project's schedule. Examples, typical examples of inexcusable delay: failure of the contractor to properly man the project in order to perform the work in a timely manner, failure of the contractor to coordinate their equipment, material deliveries, failure to provide submittals in a timely manner, and of course there's the generic project mismanagement, which frequently comes up in the context of a delay claim. Another thing, however, not noted in most contracts, not noted in any contract that I've ever seen actually, but good case law throughout the United States, is any delay that was reasonably foreseeable by the contractor at the time the job was bid. Any delay that was reasonably foreseeable when the bid was prepared and submitted. And that sounds a bit odd. People don't think about that very often. So let me give you a relatively recent example. This is not new law, by the way. This goes back, to the 1940s. But the most recent example, if you were doing construction a few years back when the Chinese were building the facilities in Beijing for the Olympics, you will realize that structural steel was nigh unto impossible to get in a timely manner. Cement was difficult to get, and there are various other products that probably were difficult also. Why? Because the Chinese were buying all that sort of material globally in order to support their multi-billion-dollar build-out for the Olympics. A number of contractors throughout the United States who were building government jobs, highways, buildings, whatever, had trouble getting their supply of structural steel. They all filed what they called a force majeure claim. They wanted time, no money, on the basis that they couldn't obtain the materials in a timely manner due to this outside influence, the Chinese construction of the Olympics, and were somewhat or more or less surprised to find that the government said, no, you're not entitled. We don't care that it had nothing to do with your project. You are not entitled to receive a time extension. And the rationale of the court was, well, if you bid the project on or after a date certain, and I don't remember how the court determined whatever that date certain was, but if you bid the project on or after that date, you knew or you should have known of the possibility of the shortage of structural steel due to the impact of Chinese construction in Beijing. Therefore, we will assume that you took this into account and you put a contingency in your contract. And of course, the contractor is saying, fellas, this has never happened before in the history of the world. We had no idea, even if I had taken it into account, we had no idea what you would put in for a contingency, how to handle it, or anything else. And the government stuck to their guns and did not give any time extension. So that's the sort of thing where a situation that an arbitration panel or a court at the end of the project perceives as being reasonably foreseeable by the bidders at the time of bidding will not be allowed as an inexcusable delay, or will not be allowed. It is an inexcusable delay, rather. I'm sorry. The next type is excusable delay. Inexcusable, nothing. Excusable. This is unforeseeable, third-party cause delay or delay beyond the control and without the fault or negligence of the owner or the contractor, including your agents, your subs, suppliers, vendors at any tier, so on and so forth. And again, the end date of the project schedule is impacted. Examples of this are things like acts of God, fires, strikes, acts of the government, sovereign capacity, acts of war, or acts of terrorism, freight embargoes, so on and so forth. Typically, the excusable delay clause, also known in many contracts as the force majeure clause, typically those clauses give you a list of examples, and if it is a list of examples, it's not considered an all-inclusive list. In other words, if the thing says events such as acts of God, fire, strikes, so on and so forth, that's a list of examples. So you're going to have to go back to the definition of excusable delay: unforeseeable third-party cause not under the control of the contractor, that means it's simply a list of examples, and if you can meet the basic definition, contractors are entitled to the excusable delay. On the other hand, there are a number of what I call bespoke contracts. These are specially negotiated, specially written contracts, typically applied right now, in my experience, on public-private partnership projects. And those tend to be modified. They specifically say it's an all-inclusive list. So the examples, they don't say examples, things included are the following, and then they give you all the things that are not included. So that's excusable delay. Compensable delay is unforeseeable delay caused by the owner or anyone for whom the owner is responsible. If you have outside designers, external construction managers, or geotechs, or inspection authorities, or whatever, or delay caused by a situation for which the owner has assumed contractual liability. And again, the end date of the schedule is impacted. Now, what's a delay for which the owner's assumed contractual liability? I mean, obviously, if the owner doesn't turn around shop drawings within the time frame outlined in the contract, that's something the owner or their agent is responsible for. But what's this assumed liability issue? Well, the primary example that I'm familiar with and have been familiar with for 46 years now is the differing site condition clause. Under the terms of the most differing site condition clauses used in almost all standardized contracts in the United States and virtually all federal contracts and many state and local contracts, the owner assumes the liability for all latent site conditions, unforeseen site conditions, differing site conditions, whatever terminology you want to use. So when a contractor hits water where it's supposed to be dry, it's not like the owner put the water out there. The owner assumed the liability for a situation like that. And why would they do that? Because it helps drive down the contractor's contingency during bidding, leaving the owner to pay only for those things that are not known at the time of bidding that impact the time and cost. So examples of unforeseeable delays, change orders, delayed responses, suspensions of work, differing site conditions, parallel prime delays. I don't know if any of you work in an environment where multiple prime contracts are required by ordinance or statute or perhaps local practice. But for example, when I worked in Wisconsin in the late 1970s through the end of the 80s, in Wisconsin, it was illegal for a public works owner to bid and execute a single general contract for any public works project in the state. And the bottom line is that the owners were required to issue mechanical, electrical, and plumbing MEP contracts, separate prime contracts. And because none of those types of contractors could hold a general license in that state at that time anyway, by default, the owner had to issue a fourth contract, which we euphemistically in those days called the general contract, which was anything not in the first three. So you had four independent prime contracts, all of whom had a contractual relationship with the owner, none of whom had a contractual relationship with each other. So if the general contractor was late or messed up something and the electrical contractor suffered a delay, the electrical contractor filed a claim, a time extension request against the owner. Why? Because the way the law worked is, well, it was the owner's responsibility to coordinate these things so as not to cause a delay. And so that's another case where the owner had assumed certain contractual liabilities, although in this case they might not have done so willingly. And finally, there's concurrent delay. Now, this one is rarely, if ever, discussed in the terms and conditions of the contract. If you go to Article 1 of your contract where they have definitions, look under C, and the odds are probably 9 out of 10. There's no such definition of concurrent delay. However, it is almost always argued on a construction site when a contractor comes in with a request for a compensable time extension, and the owner says, oh, yeah, you're right, we did screw up those drawings, but your crane was broken down for 7 of those 10 days, so I only owe you 3. That's called concurrent delay. Concurrent delay is generally defined as 2 or more delaying events occur. They may be caused by the same or by different parties. Either event on its own would have caused a delay to the end date of the project. That is, scheduled delay would result if either event arose. The delays do not have to be of equal duration. They do not have to start and stop on the same dates. In other words, they don't have to both start on the 1st of the month and complete on the 15th. One can start on the 1st and go to the 15th. The other one starts on the 10th and goes through the 30th. That 5-day overlap between the 10th and the 15th, the overlap is the concurrent delay. A concurrent delay may also occur if events fall that affect one event affects parallel critical path activities. Remember the definition of critical path. The classic definition is the longest uninterrupted chain of activities through the schedule, which allows for the shortest amount of time in which the project can be constructed. I don't think I have ever seen an as-planned or initial project schedule that shows parallel critical paths. In other words, two paths, both of which have 730 calendar days duration. But I have seen multiple times during a schedule update 18 months into a job, various events may have occurred that creates, at least for 1 or 2 months, parallel critical paths. And under the court decisions in the U.S., if there is a single event that affects both parallel critical path activities at the same time, it too is a concurrent delay. Now, there are also 3 other types of delay not talked about here, and we'll deal with that a little bit later on as we go through. Pacing delay, float consumption, and early completion delay. They're kind of beyond the scope of this particular webinar. Anyway, what we want to look at is a single case called George Solit Construction Company v. U.S. Solit is not an earth-shattering case. It didn't set new law like the Spearin case did in 1918, but it did something quite unique. So let's give you a quick synopsis of the case, of the project. By way of background, 1995, the Navy awards a construction contract to Solit. The contract was supposed to run from mid-March of 95 to the end of May of 96. Contract didn't complete until the beginning of September, so it was 96 calendar days late. In October of 97, Solit submitted a delay claim for both compensable and excusable. Remember, compensable is when the contractor is entitled to both time and money. Excusable, he's at least entitled to receive additional time and the forgiveness of liquidated damages for that amount of time. In December of 1998, the contracting officer, the Navy's contracting officer, rendered their final decision, which, not surprisingly, said no time extension. A year later, in December of 99, Solit appealed to the U.S. Court of Federal Claims. A trial was held 3.5 years later, in August of 2003, and in February of 2005, another year and a half goes by, the decision was issued. Now, what makes this case unique, like I said, it's not earth-shattering, it's not changing the ground rules. What makes this case unique is that the court surveyed all federal court cases concerning delay damages, and impact damages going back to the early 1900s. The judge, the presiding judge in the case, then included what he called an index of legal issues presented by the courts in the final written decision. By the way, if anybody wants this decision in that white paper I mentioned, we give you the full citation of this case. You just go online and pull it down yourself. But he wrote the index of legal issues presented, which was, in my opinion, a sweeping review of federal court legal rulings concerning delays and delay damages. And the judge conveniently divided the list into compensable and excusable delays, and then addressed concurrent delay issues likewise. So he kind of touched all three bases, that we talked about earlier. Now, the index, I believe, and that's why we wrote the research paper and then now this webinar, the index provides a checklist for contractors, owners, and construction managers. When you're dealing with time extensions, this is kind of a checklist of things that contractors should do, questions they should answer to the owner when they're making the time extension request, and that's what we want to go through. So we're going to start with the compensable delay issues. These are the types of delays where the contractor is not only asking the owner for additional time, but they're asking for time-related damages. The judge started simply saying that the government or the owner is liable for an equitable adjustment. That's the attorney's name for a change order or a claim settlement. When the owner causes delay to the contractor's performance. And they took a look at the typical suspension of work clause, saying the owner is liable under a suspension of work clause if the end date of the work was actually delayed. And here they reached back to the Merritt, Chapman, and Scott case in 1970, not a new case. They noted that the government or the owner is liable for a time extension under the changes clause if the contractor can demonstrate that the changed work actually delayed the end date of the project. And they reached back to the Coley Properties case in 1979. And the owner of the government is liable under the differing site condition clause if the differing site condition or latent site condition actually causes a delay to the end date of the project. And here they cited a slightly more recent case, Baldy Brothers Constructors from the year 2001. However, they parenthetically noted that the contractor is obligated to prove liability, causation, and resultant injury. Liability, you'll also hear me refer to that as entitlement. That is something happened on the project during the performance of the work, not supposed to happen per the terms of the contract, which entitles the contractor to seek recovery of either time or money. Causation, that thing that happened caused the contractor to do something they would not have otherwise done. An example, working on a highway department, I was working for the Caltrans, the California Department of Transportation, as a claims consultant in the 1990s, and there was a road widening project up through the Central Valley of California. The job's a hard dollar, low bid sort of job, no big deal. They had a geotechnical report attached to the project, and the contractor relied upon it, and it showed that the groundwater would not come any closer than 20 feet to the surface. The deepest cut the contractor had to make to install this, to widen the road was about 8 to 10 feet. When the contractor got out there, by the time he got to about 6, 7 feet, water was coming into the excavation substantially. The contractor had to go out and rent and install and operate for a period of several months a movable or transportable groundwater control system, pumps, discharge pipes, et cetera, and all the power to do that. And so that the liability or the entitlement was the latent site condition unrevealed to the contractor at the time of bidding. The causation was, this is what I had to do. I had to go get this dewatering system and operate it for 3-4 months, whatever it was. Resultant injury, which you and I both would refer to as damages. How much time and how much money did it cost as a result of this issue to which you're entitled that caused you to do that? So that's the three-pronged test of a claim: entitlement, causation, and damages. And in this case, the court reached back to the Wunderlich contracting case in 1965 and the Servodone construction case in 1991. The court parenthetically noted, however, and they went on to the next case rather, and they noted, the owner of the government's liability is limited to unreasonable delays. And they cited the John Johnson case in 1967, that liability under the suspension of work clause is limited to unreasonable delays. For example, on a differing site condition, once contractor has encountered a differing site condition, he's required by the terms of the contract to stop working, at least in that area, and to give the owner an opportunity to come out and investigate and see what they're complaining about, and then go back to work. So if the owner responds promptly to a notice of differing site condition, takes 2 or 3 days to get people out there to look at it, to run the test or whatever, for them to reach a conclusion, that's not unreasonable. If it takes the owner in in here in Denver, for example, the Denver area where I live, 3 weeks to get a geotech to go out and take a look at it, that probably is unreasonable, because there's got to be at least 30 or 40 well-known geotechnical engineering consultants in the greater northern Colorado that could have been mobilized within a day. The court acknowledged that some situations allow the owner or the government a reasonable time to make changes to investigate alleged differing site conditions without causing a quote-unquote delay, citing the Essex Electro case in 2000. And reasonable versus unreasonable delays are dependent upon the circumstances of the situation. And what we're talking about here is where are you working? I've worked on a number of projects in northern Alberta, in Canada, and in northern Alaska, up in Nome Province, or Nome District, I think that's what they call it. And in the middle of winter, because of the weather conditions, there are no roads. There's no road access. Everything that you get up there in the middle of winter is likely to be flown in, and it may be a week or more before the weather clears enough to actually fly somebody in. So if you have a situation where you need additional equipment or specialty consultants or something like that, you may have to wait a period of time, whereas, like I said, in Los Angeles, my goodness, I could get a 100-ton crane in 8 hours if I wanted it. So that's a situational analysis, and that's what the court's referring to here when they cited the P.R. Burke case in the year 2002. However, the court noted, delays caused by defective specifications are always per se unreasonable. And the idea here is that the contract documents were defective when they were put on the street for bidding, but neither the owner nor the contractor recognized that. If the owner had recognized it, or if the contractor had brought it to their attention, the owner could have fixed it before bidding. And the bottom line is that what they're ruling here from the Essex Electro case is that all of the time spent for the contractor attempting to comply with the defective specifications was wasted time. So that amount of time, would be unreasonable delay on the face of it, and then whatever change the owner had to make to fix that, likewise, is unreasonable, because if the job had gone out without the defects in it, none of this would have happened. Next thing the court addressed, the owner or the government's action or inaction must be the sole proximate cause of the delay. The contractor has to prove that the owner-caused delay was both the direct cause and the only cause of the delay, and the contractor would not have been delayed by any other reason on the project. And here the court reached back to a 1992 case called Triax Pacific. And they noted here, based on Merritt, Chapman, and Scott from 1976, even if the government caused an unreasonable delay, the owner would not be liable if the work would have been delayed for any other reason. So they're starting to dip their toes a little bit into the area of concurrency of delay, and we'll get into that shortly, because they spent a lot of time in this case, or in this analysis, talking about concurrent delay. They noted also that under the suspension of work clause, these are the two types of clauses, the 1994 and 2004 clause. No adjustment shall be made to the extent that the performance would have been suspended, delayed, or interrupted by any other cause. I don't think that's normal language in any contract but a federal contract, although I have to point out that if you have an owner who's working under a federal grant, for example, a highway department, they may well have that language in there because it may be a condition of the grant, receipt of the grant money. The burden of proof for compensable delay is borne by the contractor. Well, that's not exactly a new rule. That makes sense. The claimant, whether it's the owner or the contractor, the claimant has the obligation to prove entitlement, causation, and damages. So here, since we're talking about delay and delay only, the contractor requesting a time extension, the contractor is the claimant, they must prove the extent of the delay, that the owner or the government was the sole proximate cause of that event that delayed, and the delay harmed the contractor. And the harm here would be the time extension and or the delayed related damages that go with it. And here they reach back to the Wilner case of 1994. In some cases, citing P.J. Dick from 03 and CEMS from 03, in some cases, the government, the claimant, the contractor, has to prove the owner's delay was unreasonable, the owner's delay was the sole proximate cause of the project delay, the delay harmed the contractor, that is, caused them to be on site longer than they would be otherwise, and there was no concurrent delay, again, dipping their toes into the pool of concurrent delay. And the court noted, not surprisingly, that proving compensable delay is a lot more complicated when both parties contributed. When you have concurrent delays, proving the actual delay or disaggregating it to try and figure out how much time and or money the contractor's owed is a lot more difficult when it overlaps the contractor's own delays. And here we get to the first part of the real detailed discussion of concurrent delay. The court noted that the contractor, as the claimant, bears the burden of separating and apportioning concurrent delays. Now, they define the term concurrent delay here as when both parties cause delay by separate and distinct actions within the same time period. Again, however, as I noted before, the same time period doesn't both mean we start on the 1st and fix it on the 15th. There's an overlap in there. The Beauchamp construction case from 1988 and the Tiger construction case from 1994 are the two cases that the court cited to support this particular statement. They noted that time and cost of the delay must be allocated between the parties. They noted, citing the Koth and Goss case, a 1944 case, 74 years ago, and the T. Brown Constructors case, a 1997 case, they noted that recovery of compensable delay is barred. It's stopped. It is forbidden. When clear apportionment of concurrent delay is not performed by the contractor. Now, allocation and apportionment are unfortunate choices of word, in my opinion. We're not talking about, if you've ever been in a car wreck or car accident and the insurance company says, well, the other guy's 60% responsible and you're 40% responsible. That's not what they mean. What they're talking about is if there's a 100-day delay to the end date of the project, the contractor has to determine how much of the delay was concurrent with their own delay. And let's say that the out of the 100 days, 25 days overlapped contractor-caused delay, so the compensable delay request would be reduced by 25 days. So instead of 100, you'd ask the court, or ask the owner rather, for a 75-day time extension and 75 days of delay damages, and separately you would ask them for 25 days of excusable non-compensable delay, which would entitle the contractor to a time extension of 25 days, no time-related damages, but no liquidated damages for that time extension period. So that's what they're talking about when they say allocation or apportionment. It's a bit different than the way perhaps you and I talk about this in normal daily English. They say here, citing the Klingesmith case from '84, the contractor, as the claimant, has the burden of apportioning concurrent delay. And this is not really a game changer so much. It's kind of a reminder, apparently, of law that has existed for many, many years. Typically, a lot of people in the business believe concurrent delay is an owner defense, and the owner has the burden of proving it. So if I ask you for 100 days of time extension and you can prove that 70 of those days were actually concurrent with my own delay, you've defended yourself against the delay damages and reduced them from 100 to 30. Likewise, if you assess liquidated damages against me for 100 days and I can prove 75 of those 100 days are concurrent with yours, I've reduced my exposure to liquidated damages from 100 to 25 days. And so a lot of people say that, gee, this is what they call an affirmative defense. And by making that affirmative defense, the owner would have the burden of proving it in this case, or the contractor in another case. But that's not so, according to the decisions that the Solid Court found. They're not writing these decisions, they're simply finding them, putting them in a logical order, and applying them to this particular situation. The contractor has to prove there was no concurrent delay, or if there was concurrent delay, they have to prove that they've removed that concurrent delay. Let's see, where are we? Oh yeah. Furthermore, the court concluded, citing the Blinderman case from 1982, that recovery of the entire compensable delay will be prohibited, denied, when the delays are concurrent or intertwined and the contractor has not separated its delay from the owner's delay. And this is the case, frankly, that where the judge wrote the classic article, or the classic statement, that to be concurrent, the delays have to be inextricably intertwined. And what the judge meant there is that there's 10 days of delay that are concurrent, and you can't go through any of the 10 days and determine, are you responsible versus me, so on and so forth. On each day, both of us are completely intertwined. Our delays are so intertwined you can't separate them, and that's what they're referring to here in the Blinderman case, and applying in the Solid case. The contractor must prove the extent of the government-caused delay and its increased cost. So this is a bit like a multi-step country line dance. First, the contractor, as the claimant, has to prove the extent of the unreasonable owner-caused delay, that is, how many days of delay to the project's critical path actually resulted from this event for which the owner or somebody they're responsible for is responsible. And here the court reached back to the Servidone case in '91 and the Wilner case in '94. And that's not the end of it. So let's say I can prove your 35 days, your delay caused me 35 days, additional time on site. But the bottom line is, I then have to prove to you what's the cost of a day of delay. So first is the time, then comes the money. And here they cited the John Johnson case from '67 and the Wilner case from 1994. Then they got into the increased cost of winter work. Is that or is it not compensable? Part of Solid's claim is because the owner caused, the government caused a delay to their work, they pushed work from a good part of the year, like the summer or the fall, into the dead of winter, and that it caused a delay as part of their damages. The Solid court took a look at that issue and concluded that as far back as 1909, and that is not a typographical error, it's 109 years ago. As far back as 1909, U.S. courts recognized that if a government-caused delay pushed the contractor into winter work and the contractor can demonstrate the increased cost of doing that work in the winter, it is compensable to the owner, to the contractor rather. They dealt with the increased cost and loss of labor productivity due to winter work may be recoverable. Here they cited, as I said, Owen case in 1909, J.D. Hedden from 65, American Lines Builders from 92, and Youngdale and Sons from 93. However, they did note in the Solid case that recovery of winter construction costs is dependent upon proving that but for and only but for the owner's caused delay, the work would have been completed prior to the winter period. So if the contractor can't prove that, then they're not entitled to these damages. Again, putting their toe into the concurrent delay thing. In addition to apportioning concurrent delay, the contractor must apportion the increased cost of winter work issue. And they cited the Luria Brothers case in 1966 and the Cheney and James construction case from 1970. When establishing the government's delay to project completion, the contractor, as we noted earlier, has the burden of proving critical path delays. So whenever you're arguing delay, the contractor, as the claimant, has to prove that the delay actually impacted the critical path of the project schedule. So in order to recover compensable delay, the contractor has to do critical path analysis. And they cited the GM Shoup case from 1984, the Wilner case from 94, Kinetic Builders from 2000, Essex Electro from 2000, Sauer from 2000, and the PCL Construction Services case from 2000, a case that I had some tangential involvement with a number of years ago. The court provided a lengthy citation from an older case to define the term critical path, but in my opinion, it's really more discussion than a usable definition. But they were citing the Haney case from 1982. I believe, reading the Haney case and reading the classic definitions of the term, I believe that the Haney discussion conforms to the more concise classic definition, which, as I mentioned earlier, is the longest continuous chain of activities through the logic network, which establishes the minimum overall project duration. The bottom line is the courts subscribe to the longest path test, not to the least float test. I don't find that terribly surprising one way or the other, but some people who've read this case or attended this webinar have and have questioned it. And the reason that the Solid Court reached this situation is that on a job run on a critical path schedule network, only work on the critical path impacts the completion date, and therefore only critical path analysis can demonstrate the impact of the owner's caused delay. And here they cited PCL Construction Services and CEMS cases. Non-critical path delays, according to the Solid Court's decision, do not delay the project and therefore do not justify the recovery of compensable delay, again citing both cases. I want to add personally, and while I agree, if you have a critical path schedule and have delays that do not impact the critical path, you are not entitled, as a contractor, rather the contractor is not entitled to a time extension, nor are they entitled to time-related damages. Having said that, however, while the Solid Court didn't mention this, I suspect it's because the Solid case didn't have a situation like this, but delays to a non-critical path, a non-CPM path or non-critical path, however, may still provide grounds for impact damages claims. So let me give you a quick example. And I came across this. I think it was in 1980 was the first time I dealt with a claim of this nature. My client was a public works agency. They were building or modifying a waste treatment facility that was built on an island in Lake Michigan. For those of you who've lived and worked in Michigan or Minnesota or Wisconsin, you know that during the winter months it's really, really cold up there. In an earlier part of the project, the public works owner had delayed response to a number of submittals provided by the contractor, which caused a delay to certain concreting work that would have been accomplished in the October, November timeframe, and got pushed into the January, February timeframe. However, those concreting activities had a sufficient project float that even though there was a delay to the submittal responses, did not impact the project's critical path. But having said that, the question arises, can you place concrete at sub-zero degree weather? And the answer is, yep, you can. However, the cost of concreting in those days was about $90 a cubic yard in place on that project, and the cost of concreting in the middle of January, February, when the temperature rarely came up to zero, certainly never went above freezing, was approximately $300 per yard in place. Because of all the extra stuff you have to do to place cold weather concrete, got to mix it with hot water, move it from the batch plant to the site, and get it out of the truck. By the way, moving insulated trucks, get it out of the truck within less than 2 hours. Once you place it, you've got a sufficiently large placement. You cover it with visqueen, you cover it with hay to help keep the heat from the chemical reaction of the concrete in place. Ultimately, when you get your placement done, you construct that visqueen tent over it, and you put propane heaters in there and bring the temperature up to, I think it was 40 degrees or something like that. It can be done, but the cost of doing it goes up astronomically. That is an impact damage claim, which is separate, entirely separate from a time extension request. Now, there may be impact damages within the context of a time extension, but the fact here, in this particular example, there was not. Okay, and in citing the closing out this discussion here on CPM delay analysis, the court cited the Hoffman construction case from '98. When a contract utilizes CPM scheduling, the contractor must prove critical path work was prolonged in order to prove the delay in the project completion. And I agree with that. However, what I want to point out is that doesn't deal with projects where CPM is not required by the contract and the job is run off of some other form of schedule. And there are multiple forms of scheduling. In fact, I participated in a discussion panel one time when we were asked to try and define all the possible types of schedules, and I can tell you there are 14 different types of scheduling. Only a few of them are actually logic networks. So, what do you do? The Solid case doesn't address that issue one way or the other, but what I will point out is the construction forum prepared and published a white paper several years ago on how to prove delay on non-CPM scheduled projects. And if you're in a situation such as that, and if you're interested, I'll let you know at the end of the webinar how you can get hold of a copy of that one too. The court noted here, the Solid court noted, because critical path changes over time, critical path schedules are needed to schedule updates are needed to analyze delays. The courts understand that critical path is a dynamic critter. Things that start off with 50 days worth of float on it, 6 months later may be on the critical path. Things that are on the critical path in month 7 may be off the critical path in month 12, so on and so forth. So activities may drop off or be added to the critical path. And here the court cited the Sterling Millwrights case in '92, and therefore they said CPM updates are required if the contractor wants to use critical path to analyze and document delay, citing the Fortruck contractor's case from '85. They noted, the court noted that accurate schedule updates generated during the life of the project are better tools for analyzing delay than a baseline schedule. And they reached back to the Blinderman case from 1997. This pretty well puts to bed the old as-planned versus as-built schedule delay analysis if you're going to court or perhaps even if you're going to arbitration. However, I have to tell you, it's been my experience as recently as even this year that the as-built versus as-planned versus as-built schedule delay analysis is still the most commonly used methodology for delay analysis on most every project site I've been involved in. Again, getting back to concurrent delay, the contractor bears the burden of apportioning concurrent delay. The contractor is the claimant to apportion the delay in order to recover the delay damages. Been mentioned earlier, cited again, and to drive the point home, the Solid Court said the courts will deny recovery when delays are concurrent and the contractor doesn't segregate their delay, citing Klingensmith from 84, Avedon from 88, and Blinderman from 97. This was obviously a huge part of the Solid case. Since delays not on the critical path don't cause project delay, accurate critical path analysis is essential to determine the concurrent delay, citing Kelso v. Kirk, 94. Again, the mega construction case cites the contractor has to, seeking recovery has to disentangle it, and for delays to be concurrent, the contractor must prove that either delay on its own would have impacted the critical path of the project. The contractor may recover wage rate increases that would not have occurred but for the government's caused delay. Solid sought compensation, like the winter work costs. Solid sought compensation for increased labor cost when some of their activities were delayed, forcing that labor into a higher wage rate period. The court acknowledged those damages may be recoverable as compensable delay, citing the Hedden case and the Luria Brothers case, but the contractor still has to prove the extent of the delay and must prove, like the winter work, that the work would have been completed prior to the wage rate increase, but for and only but for the government's or the owner's caused delay. Getting into the area of damages, the contractor has to prove the amount of the field and home office overhead related to the owner-caused delay to project completion. So Solid here claimed extended field and unabsorbed home office or extended home office overhead cost. The court confirmed that extended or unabsorbed home office costs are recoverable, and they went back as far as the Fred Combe case in 1945, nearly 75 years ago, reiterated in West v. Allstate Boilers in 98, and likewise they confirmed that the contractors are entitled to extended field office costs, citing the Luria Brothers case from 1966. So that established the basis of it. Now they went out and dealt something a little bit unusual. They said when the parties stipulate the daily cost of home and field office overhead, the contractor has to prove the extent of the owner's caused delay, but is relieved of their obligation to prove increased cost. In the Solid case, the contract stipulated home office and field office overhead costs, and the government apparently tried to argue the home office cost side, saying, "Hey, well, you know, we haven't been given a chance to audit this. He can't prove this home office overhead increase as a result of this." And the court stated, "Well, you know, that sort of stipulation in the contract eliminates the requirement for separate proof of likely damages." And they noted simply that multiplication of the days of compensable delay times the stipulated delay cost is sufficient for their purposes, which is a fairly simple, straightforward response to the government's argument. However, again, citing the concurrent delay issue, the concurrent delay has to be apportioned between, or concurrent delay must be used to apportion extended overhead costs. So that's no big surprise because they've said this several times. And when multiple delays by one party are concurrent with their own delays, Those parties' delays must be analyzed to ensure overall effect of multiple delays are correctly contributed. That's a kind of a tough thing to describe. Let me suggest to you what they're talking about here is, if you create a chart of all of the owner's delays and then overlay that with all of the contractor's delays, and you find concurrency. But if you separate those again, if you find out that there's 6 contractor-caused delays, but 4 of them overlap each other to some extent or another, you have to eliminate the overlap. And you may find that 60 days of what appears to be 60 days of owner-caused delay, or contractor-caused delay, rather, is actually only 40 days when you get rid of the overlap. And that's what they're talking about. The claimant has to first examine the delays caused only by one party to make sure those concurrent delays are not double counted. And then they can compare that to the other party's delays to try and determine the concurrency of the situation. Solit wrote, the approach of comparing one party's overall delays with the other party's overall delays is more reliable than checking each individual delay from one party against all possible delays from the other party. And again, they cited the Blinderman case. The only way to accurately assess the effect of an alleged delay on a project is to contrast updated CPM schedules prepared immediately before and immediately after each purported delay. So that's the sum and substance of the compensable delay stuff. Taking a quick look at the excusable delay, non-compensable, the owner has the initial burden of showing late completion, and the contractor has the burden of showing that some or all of the late completion was excusable. So the Solit Court pointed out, when the government, the owner, assesses liquidated damages, they have to prove A, the project was not substantially complete by the contract or the adjusted contract completion date, and B, the period for which the liquidated damages are being assessed is the appropriate period. They noted, citing the PCL Construction Services case, once the government meets their burden of proof, those 2 points above, the contractor has the burden of proving excusable delay to show that liquidated damages should be reduced or eliminated entirely. So here's the case where the contractor uses concurrent delay as a defense against some or all of the liquidated damages to be assessed. They noted here, citing the Schmoll case from 1940, the Levering and Garages case from 1932. Those are 72 and 86 years old cases, respectively. When the government prevents the contractor from completing work on time, the contractor is relieved of the obligation to meet the contractual completion date. That's true, but both of those cases also stand for the proposition that they're not obligated to pay liquidated damages. And again, that's true. So it's 2 different statements combined into one. The Solit Court noted that when the delay is caused by owner action or inaction, there is some controversy over whether liquidated damages are entirely voided or simply reduced, consistent with the apportionment of delay. And the R.P. Wallace case from 2004 showed that liquidated damages are apportioned. The PCL Construction Services cases listed cases on both sides of the argument. The court concluded that the issue of apportionment versus waiver of liquidated damages is an unsettled issue in the federal courts, which I found a bit surprising. When the government causes, they went on to comment, when the government causes part of the delay, liquidated damages are either waived or apportioned. They cited some older cases saying that when the government contributes to the project delay, not when they cause it all, when they contribute to it, the rule of the original contract cannot be assisted upon, and liquidated damages are waived. They cited United Engineering from 1914, 104 years ago, Acme Process from 65, PCL from 2000. They then went on to note that that rule was criticized or ignored in other cases, showing these. And then there's a long list of cases in which the federal courts have ignored the full waiver of liquidated damages and opted for the apportionment. We're not talking apportionment of the dollars of delay of liquidated damages. If delay LDs are $10,000 a day, we're not talking about apportioning $10,000 down to $6,000. What they're talking about is if there's 100 days of delay, owner is responsible for 40, contractor for 60. The owner's concurrent delay, 40, reduces the contractor's liquidated damage to 60 days times 10,000, not 100 days, and that's what they're talking about here. And again, they determined the issue of waiver versus apportionment is undecided. I've been in this business 46 years. I have never seen a case, been involved in a case, heard of a case in those 46 years in which liquidated damages were entirely waived unless the contractor could demonstrate that the 100 days of delay of late completion, rather, was entirely concurrent between the contractor and the owner. A pretty rare circumstance. What I would recommend owners and contractors, if you're concerned about this, talk to your legal counsel who's familiar with construction litigation in your jurisdiction, and they can provide you a much more in-depth discussion than what I've shown here. Now, some more recent developments. SOLA was decided in 2005. Subsequently, we have two cases, one in 2010, one in 2011. The Meropakis case dealt in detail with concurrency of delay issues. The Wheats Company dealt with the issue of dealing with contracts with no schedule updates. Meropakis, again, a Navy contract. The Navy issued the contract to Meropakis in '99, original completion date mid-January 2000. It was later modified to early February 2000. Couldn't be a very big contract. The LDs were only $650 a day. Surprisingly, Meropakis didn't even start work until after the contract completion date. I have no idea why, nor do I have any idea why the owner didn't terminate him, but they didn't. So, but they didn't complete the work until mid-May of '01, so it's 467 days after the modified contract completion date. After completion, Meropakis sends a letter. They requested 447 days. That's not a typo. They apparently admitted there was 20 days that they're responsible for. They requested 447 days of time extension, based on 5 delay events. However, Meropakis did not certify their claim as required under the Contract Disputes Act, nor did they request or receive the contracting officer's final decision on the time extension or the delay claim, again, as required by the Contract Disputes Act. That is a federal statute that applies to all direct federal contracts worldwide. Whether it's mentioned in the contract or not, it is irrelevant. 3 months after this letter comes in, the contracting officer notified the contractor the information submitted was insufficient to justify time extension, and they rejected the request, but they invited Meropakis to submit further documentation. So they didn't really deny the claim. 10 months later, the Navy notified the contractor that since there was no additional information submitted, they were going to assess the LDs for the entire 467 days late completion. 1 month later, Meropakis sends a letter. He mentions all 5 delays, but he only discusses one in any detail, asking for 107 days, but did not certify it nor request a final decision. Finally, in December of '02, the contracting officer issued the final decision concerning the assessment of liquidated damages, not the time extension, only the assessment of liquidated damages. And the Navy later contended that was a final decision only on the LDs, not on Meropakis' delay claim. December of '03. Meropakis appealed the decision to the Court of Claims. The Navy responded by counterclaiming the liquidated damages. No big surprise there. What was surprising is the Navy asked the court to dismiss Meropakis' delay claim for lack of jurisdiction, stating that since Meropakis had never submitted the claim under the Contract Disputes Act, the Court of Federal Claims had no authority to even hear on it. And the court agreed with the Navy's position. They upheld the liquidated damages and they threw Meropakis' claim out without hearing it. Meropakis then appealed to the Court of Appeals for the Federal Circuit. That is, in my opinion, the Supreme Court of the United States for construction contracts, because the only place to go from there is, in fact, the U.S. Supreme Court. And the U.S. Supreme Court seems to have their plate pretty full, and so I don't think they take many construction cases. Furthermore, all the appeals, all the decisions coming out of this Court of Appeals apply to all other federal appellate courts, too. So, Meropakis appeals are saying, hey, guys, we sent these letters to the contracting officer. That should be sufficient to make it a valid claim, allowing the Court of Federal Claims, the lower court, to provide jurisdiction. And, yeah, I know we weren't in technical compliance, but, you know, they had actual knowledge of the amount and the basis of the claim. And, again, the lower court should have had jurisdiction. So, to me, it's kind of like attempting to create a constructive claim. Now, the Court of Appeals took the case, they reviewed the situation and determined, well, yeah, gee, they didn't submit the certified claim, they didn't get request and receive the contracting officer's final decision. No surprise, those are factual determinations. They ruled that the Court of Federal Claims acted properly in dismissing the claim for lack of jurisdiction. However, they then said, well, we're going to look at this issue of whether Meropakis should have been allowed to at least present their delay claim as a factual defense, an affirmative defense, against the assessment of liquidated damages. Now, they took a look at the Navy's claim for LDs. It's an owner claim, a government claim. Said, you know, hey, it's a government claim. They're not required to certify it under the Contract Disputes Act, and they did have the final decision. Therefore, the Court of Claims, the lower court, had jurisdiction on that issue. They examined the issue of whether the contractor must or is required to submit a certified delay claim in order to defend against LDs, and they reached back to a Sun Eagle case in 1991, wherein they stated, when the plaintiff is challenging the government's claim to liquidated damages and making a claim of their own to recover the amount withheld for liquidated damages, the contractor's claim must first be certified under the Contract Disputes Act. In an even older case, they cited Elgin Builders from '86, where the contractor seeks to contest liquidated damages by claiming entitlement to a time extension. This is a claim against the government which must first be presented to the contracting officer. The Court of Appeals ruled, therefore, that the contract terms must meet the requirements of the Contract Disputes Act, whether asserting a claim against the government or as a defense to government action. Therefore, this court ruled a contractor can't raise excusable delay claim as a defense against liquidated damages at the end of the project unless you first submitted a certified claim to the contracting officer and requested a final decision. In summary, 9 years after project completion and 7 years in court, Meropakis was never able to present even 1 hour of argument of their claim to the courts to defend themselves against the liquidated damages. And the bottom line is, contractors cannot raise excusable delay arising from concurrent delay as a defense against liquidated damages unless they've submitted a certified claim to the contracting officer and requested and received the contracting officer's final decision. Now, that rule applies to federal government contracts because of the Contract Disputes Act. There are a number of state court cases that we found where the state courts are reaching a similar conclusion, but based upon simply the language of the contract. So this is kind of spreading across the country. So even if you're not on a federal contract, don't sit back and say, wow, it doesn't apply to me, because it could if you're in California, if you're in Minnesota, and a couple other state decisions we've seen. The Weeds Company case is a bit different. It's an appellate court case out of the Eighth Circuit, which is the Midwestern part of the United States, and they really argued over the lower court's case to exclude testimony of an expert witness. Brannon, Mr. Brannon, was the expert witness, and he was hired by Wheats, the claimant, to analyze project delays, establish causation, assess responsibility. And Wheats compared the original schedule to contemporaneous updates to determine what happened. The district court summarized Mr. Brannon's forensic delay analysis as a windows analysis of events in which they actually occurred. I have to tell you that's a overused and inarticulate. Not exactly sure, and nobody's sure exactly what analysis technique they used. Now, the argument, Washington, the defendant, argued Brannon's analysis is unreliable because he allocated most of the work to the critical path, and they couldn't distinguish between critical and non-critical work. They argued the baseline used in the forensic analysis was Brannon's own creation, making it unreliable, and they couldn't identify what activities were on the schedule's critical path. Wheats argued that in Brannon's experience on similar projects, near critical path activities should be analyzed as critical since float on a baseline is so small. There is no workable or published definition of the term near critical path that I'm aware of. Most of us, as in construction claims guys, think near critical path activities are any set of activities that is less than one reporting period off of the critical path. So if you have a calendar day contract, anything with 30 or less calendar days afloat, or if you have a workday contract with anything with less than 20 or 21 workdays float. But that's just a rule of thumb, and I'm not sure that's ever been formalized anywhere. I'm not going to go through this, the rest of this slide and the next slide, just to point out these are the rules of when a court may admit expert testimony, and that's they're here for your note, for you to read and think about. And we have a full citation of this case in the white paper, so if you want to see more, you can look at that. But the appellate court reviewed the district court's ruling, and they on the expert's testimony said, yeah, there are some weaknesses in Brannon's analysis, but they don't make the analysis totally unreliable. The report was sufficiently specific to allow Washington to challenge and demonstrate the flaws, and the argument over what's on or not on the critical path doesn't make the analysis unreliable. And now the reason we bring this up, even though it's only a circuit court, an appellate court case, not applicable nationwide, such as the other case I mentioned, the Merrill Pockets case, the Court of Appeals concluded that the lower court didn't err in admitting Brannon's analysis or testimony, even though the analysis did not identify the critical path. So the conclusion we reach, anyway, is contemporaneous critical path testimony by an expert is not always required to sustain the burden of proof concerning delay and delay damages. And we bring that up because, again, it appears to us, reading this case, there was no critical path schedule required. This thing was scheduled on some other scheduling technique. So, sum it up, checklist. Based on the checklist for compensable delay, owners are liable when they cause a delay. Their liability is limited to unreasonable delays. The owner's action or lack of action must be the sole proximate cause. The burden of proving compensable delay falls on the contractor because they're the claimant. Contractors, you bear the burden of separating and apportioning concurrent delays. A contractor, as the claimant, must prove the extent of the owner's delay and the increased cost, two separate steps. The contractor may recover the cost of winter construction if you can demonstrate that the work would have been completed prior to winter. And the increased cost, if you can prove that, the increased cost of winter work likewise must be apportioned. If there are concurrent delays, when demonstrating the extent of the government's or the owner's delay, the contractor bears the burden of proving critical path delay. and you have to analyze critical path schedule updates to analyze the delays. You can't use the as-planned versus the as-built. Contractors bear the burden of apportioning delay. Contractors may recover increased wage rate increases rather, if the labor would have been incurred earlier than the wage rate and is delayed by and only by the owner's delay. Contractors, you have to prove the amount of home and field office overhead directly related to the government delay once you've removed the concurrency, unless your contract stipulates these overhead costs, in which case you're relieved of the obligation of proving that. And when you have multiple delays, as we mentioned before, by one party concurrent with each other, that party's delays must be analyzed first in order to prove this. Recent developments, or excusable delay rather, the government has the initial burden of proving late completion. Contractors would have the burden of proving some of that or all of it's excusable. And when the government causes part of the delay, the liquidated damages may either be waived or apportioned. And again, I caution you to contact your own attorney to talk about that, because I've never seen them totally waived. With that, by my watch, we have about 10 minutes. Oh, recent developments, I'm sorry. Contractor must file a certified claim and request the contracting officer's final decision to defend against the owner's liquidated damages. You can't just wait till the end of the project. That's under federal contracts, and as I mentioned, under a lot of public works contracts I've worked on, if you don't follow the terms and conditions of the claimed process or the time extension process, you may end up in the same basket with the guys who, like Merrill Pockets did. Critical path testimony by an expert may not be required to sustain the burden of proof, and so that's one of the things you'd need to look for in your contract.